Hello, my name is Lindsey Connett. I am a lecturer in law at the University of Exeter, and prior to joining the university I was a solicitor in practice for 12 years, and today I'm going to be talking about tort law, which is a branch of civil law that I practiced in when I was a solicitor. So that's what we're going to be looking at today. So tort law is basically the obligation for how we live with other people in day-to-day life. And it's different from contract because contract is a formal written agreement that you are going to do something and somebody's going to give you something in return. Whereas tort law is that general civil understanding for how we live with other people and in our day-to-day life. So, for example, road traffic users automatically owe a duty of care to every other road user on the road with them at the same time. And that includes pedestrians and pedestrians crossing the road. So it's that type of thing that tort law covers. And my argument is that tort law affects every single one of us, whether we know it or not, whereas some other areas of law, only particular people will come into contact with. And that's why I think tort law is the most exciting area of law, because it affects absolutely everybody. So, tort law covers a number of different potential issues. The largest of these is negligence. In Exeter, we cover a whole term just on negligence and how that works out. There's also other areas of law, including torts against the person. So we think about, you probably have heard of defamation cases or battery, assault, false imprisonment. Hold false imprisonment in your mind. We're going to come back to false imprisonment a bit later in our session. We also think about harassment, privacy, and basically where people owe an obligation to keep other people safe in their day-to-day lives. So as well as torts against the person, you also have torts against land, and that is an obligation to ensure that everybody has the right to enjoy their land themselves. So, for example, your neighbours might be making a lot of noise at a party. You have a right to quiet enjoyment of your own land, and so you might be able to sue them in tort because they're making so much noise in the middle of the night. So we think about what is acceptable as nuisance. For example, noise in a city where it's very, very busy and there's trains going all the time might not be nuisance in a city, but noise of that type in the middle of Dartmoor would be, because you would expect it to be quiet in the middle of the night. So we think about how the location of the land affects the assessment of whether a tort's been carried out. I mentioned before, didn't I, about how tort is different from contract law. Well, the other area of law that a lot of people talk about is criminal law. That's the one area of law that everybody is aware of. Well, tort is different from criminal law for a number of things. So first of all, criminal law is intended to punish the offender, whereas tort law is compensatory in nature. And that just means that you take a claim in tort law to obtain financial compensation. It's not about punishment. It's not about vindictiveness. It's about being recompensed financially for the harm that you have suffered. A finding of liability in a tort claim is not the same as a guilty conviction in a criminal claim. So there's no record that passes with you. It doesn't follow you around for the rest of your life. So liability in tort is very different in that respect. The final thing about the difference between tort law and criminal law is they have different standards of proof, and that is because of the eventual outcome and the impact that that's going to have on the individual defendant. So in criminal law, the burden of proof is beyond all reasonable doubt. So if you are a statistics fan, you're looking in the 99.99%. The jury have to be convinced beyond all reasonable doubt that the defendant before them in the dock committed the offence that they were charged with. And that is so high because ultimately their liberty could be taken away from them with a custodial sentence. So it's really important that they have that beyond all reasonable doubt. Civil claims have a much lower standard of proof, and you just have to show that the defendant's action more than likely caused the damage suffered by the claimant. So we're talking about a balance of probabilities, more likely than not. And again, if you're a statistical fan, you're thinking 50% or above. Can you prove to the court on the balance of probabilities that the negligence of the defendant led to the physical harm suffered by the claimant? So it's a much easier threshold to pass than beyond all reasonable doubt in criminal law. And if you're watching this video and you're thinking about being an incoming student into law, negligence is the tort you are going to come across by far the most. And it covers a lot of different areas. So we might be thinking medical negligence, we might be thinking personal injury, road traffic accidents, employer's liability, occupier's liability, all sorts of things come under the umbrella of negligence. And very quickly, there are three main standards of test for negligence that you need to prove in order to be successful for your claim. If you fail on any of those three, your claim will fail. So first of all, you need to prove or show to the court that there's been a duty of care. And that means that the defendant owed a duty of care to the claimant. So, for example, if we take medical negligence as our test, did the doctor owe a duty of care to their patient at the time that they treated them? Now, with medical negligence, it's generally very well accepted and has been for many years that doctors owe a duty of care to their patients. That's generally accepted. Where it becomes a little bit more murkier is where you have some novel situations where it's not a well-established precedent. And then the court needs to think about, well, has this relationship between the defendant and the claimant given rise to a duty of care? And is it fair and just that we impose a duty of care on the defendant because of the financial implications that come with it? So that's the first test. Is there a duty of care? In practice, they're generally held with accepted precedents. It's not normally where you have most of the arguments. The second test that you need to satisfy is that the defendant has breached that duty. Okay, so has their standard of care fallen so far below what is generally accepted by that profession that it's negligent? And how you do that is you apply the key test of Bolam, and you go out to your expert witnesses. So if we use our medical negligence example, something happens in the accident and emergency department, and somebody suffers injury as a result. You go out, you find an accident and emergency consultant who is able to review the treatment that the patient received and tell you whether there was a breach of duty. Did the care and treatment that the patient received fall so far below the acceptable standard that it was negligent? So that is something that you really need to prove on the balance of probabilities and make sure you are over that 50%, and you use your expert witness to do that, because obviously we as lawyers, we can say what we think it is, but it's the expert evidence that's going to tell you whether there's a breach of duty. So duty of care, breach of duty. And the final test is that you have to show that the damage suffered by the claimant was caused by the defendant's breach of duty. Okay, and that's what's known as the test of causation. So you have to show that there is an unbroken line or link or chain between the defendant's actions and the claimant's damage. So did that A&E doctor, did their treatment cause the eventual injury or lifelong consequence that the claimant has suffered? And if you can establish that link and that chain, then you've satisfied all three tests of negligence. So remember, negligence is there a duty of care? Is there a breach of duty? And did that breach of duty cause the damage suffered by the claimant? And you have to satisfy all three tests. You remember at the beginning, I talked about false imprisonment as a tort in itself. And I said, hold that thought. We're going to come back to false imprisonment as we go through. Well, false imprisonment, I'm going to tell you about in a bit more detail. And then I want you to think about applying it in a real life scenario. Okay. And one that hopefully you will all be able to have some knowledge of. So false imprisonment is complete restraint. It means that the defendant is preventing you from moving in any direction, and that they, for a period of time, have you constrained in that area. Now, for example, they might have you shut in a room, holding the door shut. They might have their arms pinned up against a wall with you in the middle. An example of complete restraint. You might be prevented from walking down a train carriage because they're stood in the way. Okay, so complete restraint of your movement as the claimant. Factors to be considered when you're applying it to the scenario. There doesn't need to be a time limit. The courts have said that the merest seconds can count as false imprisonment. That you, as the claimant, do not actually need to be aware that you are being falsely imprisoned. There has been case law which says that even though the claimant was unconscious at the time, they were still falsely imprisoned by the defendant. So you don't need to be aware that you're being falsely imprisoned. If you are in performance of a contract, you can't be falsely imprisoned. So, for example, if you get on a train, you have paid for that train company to take you from point A to point B, and you have agreed that you'll get off at point B. That is a contract between you and the train company. The train company is not obliged to let you off at any point before point B. So they do not have to let you off the train at any point before your end destination, because that is the trip that you've contracted for. So you wouldn't be able to claim false imprisonment against the train company just because they refuse to let you off in the middle of a field on the way to your end destination. And finally, the really big thing is that there's no false imprisonment if you have a reasonable alternative means of escape. So, for example, if somebody's locked you in a bathroom and they're holding the door, but there is a window, then the courts have said, well, that window is a reasonable alternative escape. So you could have got out of the window, so there's no false imprisonment. What you need to think about is what level of the building are you on for it to be reasonable, because it will be unreasonable if you jump out of a window on the 3rd floor because the risk of injury to yourself is very significant. So you need to factor in, okay, what do I know about the building? Is it high? Is there a fire escape that I can use? Or do I just need to jump out the window? And then that is the sort of thing that the court will take into account when considering whether there's an alternative means of escape. Remember, I talked about the train carriage and somebody preventing you from moving up and down the train carriage. An alternative means of escape would be for you to turn around and walk to the other end of the carriage. You would be able to move away from the false imprisonment and the constraint in that way. So that is a possibility. So when we move on now to think about applying your knowledge, remember it's complete restraint. There doesn't need to be any time limits. You don't need to be aware as the claimant that you're being falsely imprisoned. If it's in performance of a contract, it isn't false imprisonment. And there's no false imprisonment if you have a reasonable means of alternative escape. And reasonable is the key word there. Okay, so we're going to think about applying your knowledge of what you've just learned. So I want you to just spend a few seconds thinking about where you can find an example of false imprisonment in a Disney film. Think about Beauty and the Beast. And actually, Beauty and the Beast is really interesting because there's 2 potential false imprisonments. First of all, her father is detained whilst he's out and about on his travels. Yes, absolutely, that will satisfy all the criteria for false imprisonment. However, what's interesting is when Belle comes to the castle, she volunteers and takes her father's place. And so there's a really interesting legal discussion there about whether the fact that she is consenting to be there in the knowledge that she won't be able to leave, whether that negates the false imprisonment claim because she has consented and volunteered to be there. And so that's an interesting debate. And I'm sure if you go now and you watch any Disney film, or in fact, any film, you will start to think, okay, where can I see torts in application in real life? And that's why, coming back to my starting argument, tort affects us all. Even when we think it doesn't, every time we get in our car and drive on the road, we have a duty of care to other road users. That means if there is an accident, we are potentially negligent. So you can see very quickly, can't you, how actually it is a huge area, even though we might not be aware of it. Okay, so thank you for listening. I hope you've learned something about tort in a very short time together today. And hopefully I look forward to welcoming you to Exeter in a short while. Thank you.